Um, we will be recording this session just in case people will be interested, which they probably will afterwards. So no worries about taking notes, just take advantage and listen and enjoy. We also want to take a moment in the very beginning to recognize that it has become a very strange and difficult time in a very short time span. We are fully aware of the violence and difficult situation in Ukraine. We want to send out our love and support to the people suffering there in sincere hope that things will be normalized very soon. And today's topic will not be related to anything in that domain, but it's a still very important issue that does have very important public interest implications. You are all probably aware that ISDS, investor state dispute settlement, has been under increasing scrutiny in the past couple of years, not only because of the growing calls from states who are interested in reforming the system, but also from civil society and other groups who are considering ways that ISDS has been harmful to society before and what can be changed in the future. And in this discussion about what is wrong with ISDS, one issue was prevalent from all stakeholders who were speaking about it, and that is the perceived lack of transparency of these proceedings. There is a perception that there is something wrong with arbitral tribunals deciding interests that are related to state measures behind closed doors and without too much insight into the proceeding. Now, whether or not this perception is all correct, whether or not it's exaggerated on one hand or the other, it is very important to address, and it's very important to see what has been done and what can be done to achieve transparency. And we are lucky today to have our esteemed guest, Dr. Luke Nottage, who will address all of these issues from his expertise and give us a little more clarity on what is really true and what more can be done in order to achieve this balance between what is the benefit of confidentiality and what is the benefit of having more transparency in investor state disputes. Before we get to the subject matter, I would just like to briefly introduce our guest. He is a professor of comparative and transnational business law at Sydney Law School, specializing in arbitration, contract law, consumer product safety law, corporate governance, with a particular interest in Japan and the Asia Pacific. He is founding co-director of the Australian Network for Japanese Law and associate director of the Center for Asian and Pacific Law at the University of Sydney. He's also managing director of Japanese Law Links and special counsel at Williams Trade Law. He is a prolific author and he frequently speaks at international conferences. Welcome, Dr. Nottage.
Thank you.
So maybe we can kick off this discussion before moving into the details of what's specific for investor state arbitration and transparency in this respect. Can you introduce us generally to what is known as the biggest benefit of confidentiality and what is the biggest disadvantage of confidentiality versus transparency in international arbitration?
Yes, I think it's useful to start with that broader picture and the broader question of why we have tended to favor confidentiality in international arbitration generally before we dive into investor state arbitration. And basically, confidentiality, I think, is a double-edged sword. On the one hand, if you think about cost and delays, which is an important issue in any dispute resolution procedure, but particularly when you get into complex disputes cross-border. On the one hand, if you have confidentiality, it can be useful in reducing costs and delays because, you know, in the procedures and then in the award writing, the counsel and the arbitrators are basically resolving an individual dispute, and they don't need to write for the broader public and so on. And so they can be more efficient, if you like, in the procedure. And we know this is particularly important in international arbitration because sort of a persistent complaint by the users and those involved in the system is that it takes too long or it's too expensive in particular. But on the other hand, if you have confidentiality, then you get a problem of information asymmetry, which you get in all types of services markets. If you think about going to take your car to be serviced at the mechanic and so on, you know, the service provider knows typically a lot more about what they're doing and what's achievable and so on than you do. So if you have that sort of information asymmetry, then it can lead in the arbitration setting to the arbitrators, but particularly, you know, the counsel involved, lawyers who generate most of the costs in an arbitration, inevitably, you know, not necessarily being the most efficient in running the procedure and so on. If you had more transparency, you might be able to better assess whether the arbitrators, and particularly the lawyers, were doing a good job for the money they're charging. So it's a double-edged sword. And if on balance, the costs and savings and the reduced delays from having more confidentiality are diminishing, this creates a bit of a legitimacy issue compared to other forms of more public procedures, such as, you know, international litigation, for example, which tend to happen in sort of open court through the public court system. Because, you know, if you, a basic principle of the rule of law is that you have, you know, a certain amount of transparency. Of course, there are exceptions for good reasons. One good reason could be, well, you want to keep the procedure reasonably efficient and not a burden on taxpayers and other people involved. But if that benefit is reduced because there's inappropriate levels of confidentiality, then this is a problem for arbitration generally, compared to, say, litigation more often in public forums such as courts. And it's a particular problem in investor-state arbitration compared to commercial arbitration. If you've got two private parties, commercial parties, who have a dispute over a contract or something with no real effects on, direct effects on the wider public, then even if their dispute resolution mechanism is a bit too inefficient, that's not so much of a problem. But if you have investor-state arbitration, usually based on a treaty commitment to run this procedure with, on the one side, a host state, then already you have a public interest, at least in that country. But also, if they're arguing about some legal measure associated with public policy in that country, public interest, then you've got extra public interests. And so it's even more important then to make sure that the system is more legitimate, and that means run efficiently. So I think that's part of the background why we have a persistent question being raised about whether the level of confidentiality versus wider transparency in investor-state arbitration is striking the right balance.
Yes, exactly. And this is why it's such a murky area. And perhaps this is why we also have many misconceptions about, first of all, the degree to which transparency is desirable or possible in investor-state disputes. But also, on the other hand, there are differences in the way that different rules govern the issue of transparency. And transparency is not just a blanket term. It can refer to many different aspects of the proceedings. For example, maybe does it refer to the participation of third party, non-disputing parties in the proceedings themselves? So many different areas and different things to consider. Could you guide us a little about the existing framework that governs transparency in ISDS in particular? What do the rules tell us now? And is the notion that confidentiality is the default rule, is it correct?
So again, I think we need to distinguish a bit between commercial arbitration and investor-state arbitration. But even interestingly, with investor-state arbitration nowadays, we do have un instant, s'il vous plaît. We even have quite a lot of transparency in some aspects in investor-state arbitration already. So a quite surprising large majority of investor-state arbitration awards are fully publicly available nowadays. And others may not have the full award available, but there's quite a lot of information about the result and sometimes even the reasoning. And that's sometimes because there's just a leak when it shouldn't have been disclosed because of confidentiality obligations. But in recent years, it's because also the treaties provide for more transparency, recognizing those public interests and the balance that we're talking about before. But even under the major rules used, adopted by agreement of the parties to run their investor state arbitrations, there are opportunities to make the awards in particular, but also other aspects of the arbitration known publicly. So one of the oldest sets of arbitration rules that are available for parties to choose are of course the rules of arbitration of the International Chamber of Commerce, the ICC, dating back before the Second World War. And even now, they're primarily an organization that's used for commercial arbitration, although some growing proportion of their cases involve state parties and to some degree. But they're sometimes referenced as a venue for investors to choose in treaty commitments made by host states to try to encourage foreign investment. And so occasionally they run investment treaty arbitrations as well. Interestingly, this older organization, one of the largest in the world, and very prestigious, doesn't have any direct confidentiality obligations on the parties themselves. Of course, the arbitrators and the secretariat of the ICC are bound by confidentiality under separate rules. But often in commercial disputes, the parties agree, opt into a confidentiality regime and so on. And the ICC is actually quite distinctive compared to other arbitration institutions around the world now, mainly dealing also with commercial disputes rather than investor-state disputes, which generally provide for confidentiality because that's sort of what, on balance, commercial parties prefer. As for the other two sets of rules that are used in investment treaty arbitration, the International Center for Settlement of Investment Disputes, ICSID, established, associated with the World Bank and with its convention of 1965, that has a set of rules for disputes brought by foreign investors from one of the ICSID member states against a host state if they've consented to this investor state arbitration, that provides that the ICSID Center can publish excerpts of legal reasoning used by the arbitrators in their final awards. And because by the time you extract those parts and publish them publicly, having agreed to ICSID convention arbitration rules, the practice is usually then to make the whole award available. And so if you go to the ICSID website, you can find lots of awards now, hundreds of awards publicly available in those cases. And the ICSID convention, the ICSID regime deals with about 2/3 of known investor state arbitrations. So that's quite a lot of publicity and transparency. The other 1/3 of investor state treaty disputes are resolved ad hoc through typically the UNSTRAL rules. And they also provide for some degree of transparency. They can publish the awards if the parties consent. But of course, if one party doesn't want to make the award public, then they're not supposed to make it available, although in this WikiLeaks era, sometimes those awards do get into the public domain as well. As for other aspects like the things you mentioned, Fahira, about submissions by the parties, the disputing parties, amicus curiae submissions by third parties, non-disputing parties, and so on, That's basically not regulated traditionally in either sets of rules, the UNSTRAL rules or the ICSID rules. And so it was sort of left to, devolves to arbitrator discretion, and the arbitrators try to weigh the sort of competing interests in these cases, bearing in mind that if it's investor-state arbitration, there are more public interests sort of that favour more transparency and disclosures beyond the parties themselves. So an example of that is, say, in the UNSTRAL rules arbitration between Philip Morris Asia, which the subsidiary of a tobacco company in Hong Kong, that claimed against Australia for Australia's legislation introducing plain packaging of tobacco products, which Philip Morris alleged was expropriation of their trademarks and other violations of an older treaty between Australia and Hong Kong, now superseded by a new treaty. But that was brought under the UNSTRAL rules, and the arbitrators ended up having to issue a procedural order directing the parties what could and could not be publicly made available. I should add that in 2013, the UNSTRAL and the UN amended the UNSTRAL rules, which are also used in commercial disputes, saying that if it was an investor-state arbitration, there would be extensive transparency, not just in relation to publicising the award, but other aspects. And so treaties concluded after 2013 that allow the foreign investor to bring a claim under the UNSTRAL rules. If they choose the UNSTRAL rules option, then they're consenting in advance to a great deal of transparency. What about the earlier treaties before 2014 that provide for the option of the foreign investor choosing UNSTRAL rules ad hoc arbitration? Well, because it's generally not advisable to have sort of retrospective effect for legal regimes, the UN through UNSTRAL developed this Mauritius Convention on Transparency, and if member states separately ratify this convention and the counterparty state has also ratified it, then it sort of retrofits these post-2013 UNSTRAL rules greater transparency obligations on all pre-2014 treaties. Although, as we'll discuss later, not too many countries have actually taken that step of committing to ratifying the Mauritius Convention to retrofit these greater transparency obligations on earlier treaties. In the meantime, as I've said earlier, I mean, different states in recent years have been building into their treaties anyway, explicitly greater transparency obligations, which leads to more publicisation of the awards and even some aspects of the procedures leading to the awards. So that's the current state of play in terms of the legal regime.
It's very fascinating, and I'm very much looking forward to discussing the tension between, you know, all these calls for more transparency that states have been especially voicing in the recent years, and the resistance to, or at least reluctance to, acceding to the Mauritius Convention with all its framework and all the specific rules that are already built in there. And another fascinating thing is to consider having this knowledge and access to all these awards, but still seeing so many calls for transparency, that it shows us that the awards themselves and the outcome of the case are not necessarily the only and crucial interest point of the states and the civil society, but perhaps more insight into what happens during the proceedings themselves, and maybe having a more flexible framework where there will not be a chance to resist transparency unless if there are some justified rules, which at the moment it's the reverse. It is, you know, you will assume it will be confidential unless if there is explicit consent to do so. So could you comment, you mentioned the exit rules and the framework that exists at the moment. And most of our guests probably know that ICSID has recently published a new set of rules, both for the additional facility, but also the arbitration rules, that aim to address and make an important move in the direction of transparency going forward. So the rules, just for everybody's information, they're right now open for votes. They should be either approved or turned down in March. So we'll see how that goes. But could you comment on what the rules give us as they stand?
Yes, so thank you. The exit rules, the main rules, so applicable to foreign investors from one ICSID member states against a host state that's also a member of the ICSID Framework Convention, actually were amended in 2006, for example, and that already started this process of expanding the transparency of that procedure, which you remember already from the outset provided for publication of excerpts of legal reasoning from the awards anyway, which often led to the publication of the whole award. But the 2006 amendments included, for example, an express mention that, you know, the arbitral tribunal could allow an amicus curiae submission. So from someone, sort of public interest group, for example, with an interest, with a perspective on the dispute, right, other than that of the parties, the disputing parties. But actually, really, that was those exit rules amendments were just restating actually the situation under the exit arbitration rules anyway, which was that was an option available for the arbitrators anyway, under their general discretion about something that's not regulated specifically in the rules or the convention. But by putting it up front, it sort of highlighted that maybe there was sort of an expectation that this would be more seriously considered by tribunals. The other point is the ICSID rules of 2006, in stating this, were reflecting actually what some arbitral tribunals had already decided under the competing, if you like, UNCITRAL ad hoc arbitration rules, where this issue came up and tribunals started to say, well, if there's sufficient public interest and this non-disputing party has something useful to add and it won't disrupt the procedure too much, then we want to hear what they have to say, which means we have to disclose some sort of information about the case, of course, to allow them to fulfill that role. So the ICSID rules of 2006 with this amendment were really just catching up, if you like, with the practice and the understandings, including under the parallel UNCITRAL ad hoc arbitration regime. Now, the current further revisions of the main ICSID arbitration rules, which have been, you know, widely debated since 2016 with lots of submissions from different member states. I mean, there's already over 150 member states to the ICSID Framework Convention and so on. So they've all had the opportunity, and many have taken the advantage of making the opportunity to make submissions on these ruled amendments. Along with all sorts of other groups and stakeholders. They propose to basically, again, expand transparency, but really align, I guess, the ICSID arbitration regime with the new UNCITRAL rules amended in 2013 for investor state arbitrations. So basically, for example, the proposed rule 62 of the new ICSID rules up for vote now go even further in a way, because they say there will be the award will be automatically published if 60 days pass and there's no objection lodged by a party. So it's like a default advance consent to publication unless there's an objection. Now, that was quite actually controversial over the years of discussion. Some member states and experts on the ICSID convention said actually those rules would violate the spirit in good faith of interpreting the convention, because the convention basically says you can't there's no obligation to disclose the whole award. It's only the excerpts of legal reasoning which are important and therefore should be disclosed, can be disclosed by the Secretariat without party consent. But in the end, because there's still one party can veto this publication of the award, it's been put forward as a rules amendment, and I imagine it will go through. The other aspect, for example, proposed in the new ICSID Rule 63 is that the Secretariat should be able to publish excerpts of legal reasoning in other decisions of the tribunal, not just awards, final awards, which is important because, for example, if the tribunal bifurcates and decides to issue a decision on jurisdiction, upholding or rejecting jurisdiction, I mean, that's not an award. So if it upholds jurisdiction and they go on to give an award, then at that stage it becomes public, or the legal reasoning at least. So that's understandable. They want to broaden that through the rules. The convention doesn't say anything about the publicity or otherwise of those non-award decisions, so there's no problem there. And I think it makes sense to make those public. For example, there's a very interesting case that's still going on under a bilateral investment treaty between Australia and Egypt. It's got some sort of unusual wording saying the host state shall consent to investor-state arbitration. There's been some discussion in other awards, including under an earlier Indonesia treaty with Australia, which has now been superseded by a newer, more clearer convention, as to whether that is an advance consent to investor-state arbitration, or whether it means the host state reserves some sort of discretion as to whether it shall in the future give consent to investor-state arbitration. Now, apparently the tribunal in the Egypt-Australia BIT dispute has decided that the parties intended that there should be immediate consent, advance consent to investor-state arbitration. But we can't see that decision because it's not a final award yet, so as part of a final award. So by making this amendment in the proposed ICSID rules amendment, we should that should remedy that situation, because actually other treaty countries occasionally have treaties that have the similar wording of shall consent, like Japan, which I'm very familiar with, has a few treaties that have that. And so it's also of interest to them and their investors and so on, and arbitrators resolving those disputes potentially. What was decided by this tribunal and why in the Egypt-Australia BIT case. In addition, the proposed ICSID rules allow the parties to publish other documents lodged, like party submissions, if agreed by the parties, or else by the tribunal at its discretion, weighing the competing interests involved in efficient proceedings compared to the wider public interest. It allows, the proposed rules will allow non-parties to attend hearings and publish and publication of transcript or recording unless a party objects. So sort of the default again is transparency. And again, expanded provisions so that tribunals may allow submissions from non-disputing parties like amicus curiae briefs. Now, all this is again subject to a party or both being able to put to the tribunal that there is confidential information that for various reasons shouldn't be put into the public domain, like trade, state secrets or business confidential information and so on. But really this is just aligning largely the new ICSID rules with the UNSTRA rules since 2013. And so I can't, and some of these aspects like allowing at the tribunal discretion amicus curiae submissions, if it's helpful for the resolving dispute, have been undertaken anyway under ICSID arbitration. So I imagine that, after lengthy consultation as well, these rule amendments will largely go through, if not in totality.
Yes, and just speaking of this evolution of these rules, it becomes very apparent how we have an instrument that has survived over half a century, and it has been very successful in creating a healthy framework for investor-state dispute settlement. But when trying to introduce improvements that were not foreseen at the time when the convention was adopted, which are necessary now with the proliferation of the number of ISDS cases and the growing interest of the population. This is where the tension that is the crucial issue between the interest of transparency and achieving transparency in ISDS arises in this sense. And although we have rules that are now apparently introducing the default rule of transparency, you have calls to reconsider this because it's still contrary to perhaps the nature of the original instrument. So would you mind taking a couple of minutes to bring us into this world of this tension? Where is it coming from? And how do you think it can be resolved? This growing interest and need for transparency, which can be accommodated, and the reluctance to actually engage and apply these rules of transparency.
So it's interesting to me and others that UN Mauritius Convention on Transparency, right, which has been open for ratification since 2014, has only attracted 9 ratifications, and of those, few of them are big players in investor-state arbitration. Yes, there's Canada 2016, Switzerland 2017, Australia 2020. But not the really big ones, like the Netherlands, for example. A lot of investments get routed through the Netherlands, or the US, or China these days. And so the question is, why is that? Why don't they sign up to this convention, hope that others do, so they can efficiently retrofit transparency obligations on their old treaties? Or why don't they renegotiate all their old treaties, like one by one then, at least, and add transparency provisions? Like, to some degree, this is happening. So I mentioned, for example, the new Australia-Hong Kong treaty, or the new Australia-Indonesia treaty, compared to the old 1990 treaties. These are there's a lot more transparency involved, and that's built into the treaty framework. But this doesn't seem to happen. So why is it? Well, I think from a treaty negotiator perspective, I mean, they prefer like a case-by-case type approach, so they can decide, they can maybe trade off transparency if it's important for them and their citizens and their civil society groups and so on. If they push for that, then the other party might ask for a concession or something. So by doing it sort of in a more case-by-case, treaty-by-treaty approach, they might generate the most, acceptable situations in each case. There's also a bit of a design flaw in the Mauritius Convention, because it only retrofits the enhanced transparency rules, equating to the revised UNSTRA rules, to all pre-2014 treaties. So, for example, Australia and Indonesia signed a new free trade agreement with an investment chapter in 2019, and now in force. That has more transparency obligations built into the treaty compared to the older treaty from the early 90s. But if the investor chooses at the moment an ICSID rules arbitration, under the current rules before these proposed amendments, there'll be less transparency associated with that. Now, even if Australia and Indonesia ratified the Mauritius Convention, because this treaty was signed in 2019, ratified in 2020, it ratchet up the transparency to the Mauritius Convention level. And so that's again a reason we'll say, well, why bother ratifying the Mauritius Convention, because it's sort of not dealing with all those situations. we have to then, if we want more transparency, we have to go back to the counterparty state and renegotiate that treaty since 2014 to have more transparency. Now, this problem may reduce as the exit rules, if the exit rules are passed with this more transparency and so on. But I think that could be a part of the reason why the Mauritius Convention hasn't taken off. But apart from those more technical and practical issues around treaty negotiations, I think also some host states in particular are not too happy about too much transparency, because it can expose the sorts of legitimate complaints that foreign investors can have about their poor governance and arbitrary decision making and favoring protectionist impulses, all sorts of things, right, that are not supposed to happen under the host state's substantive commitments in attracting foreign investment. And the flip side of that is that often, you know, it's foreign investors that are seeking more transparency, because, you know, by exposing what the host state has done, they might be able to get on side some opposition or minority interests in the host state who weren't even aware of how bad their government was, not only perhaps to that foreign investor and making this big stuff up that could cost their country dearly, but also maybe, you know, getting up to poor practices with local investors. And so there's also that possibility for some low take-up of this Mauritius Convention. And also, getting back to what I started with, another factor could be that if you've got to think about cost and delays, and if we have more transparency, that can lead to more arbitrators and counsel taking more time, even more money to resolve a dispute. And also, I mean, even these expanded transparency regimes, like the UNSTRA rules and the proposed exit rules, have these exceptions, right, for state secrets or for business secrets, legitimately, like you would have in court, public court, actually. And you can imagine that there'll be lots of disputes, even under these new regimes, about when those exceptions apply. So there's more costs and delay potentially as well. And Professor Zachary Douglas made this point, I think, quite well in a lecture he gave for our University of Sydney Clayton Utz International Arbitration lecture last year. So, so there's a combination of reasons, I think, for states to complain a lot about a lack of transparency, but then not necessarily follow up by applying it in their treaty practice.
That's a very important point, because the state has to play two fields at the same time. Of course, towards the public, and this is very visible in UNCITRAL Working Group 3, they really are making submissions about how important this is, especially in terms of the accountability of the arbitrators and having more insight into how these people are appointed, how they decide who they are, who is funding these proceedings. They're calling for transparency from many sides, but then, like you just elaborated, very practically and pragmatically, they know it's not fully in their interest. So hence, those who are not so informed in these dynamics and the thought process that goes on the policy side, but also on the public relations side, then they might be confused with this lack of adoption of the Mauritius Convention. In the Western Balkans region, we have, for example, Montenegro, Serbia, and North Macedonia who signed it, but have not yet ratified. Perhaps for these exact reasons, they were inclined to do so because they found it appealing as EU transition states. Hopefully they want to become EU member states as something positive, but still politically there was not too much appetite to ratify in the end. So we'll see how this will continue. But just another point from the region, for example, Serbia recently, the case is still pending, but the hearings just finished in a case called Rand Investment versus Serbia. And it's the first ICSA case, and please somebody correct me if I'm wrong, but that had fully transparent hearings. So even though they're not a member party of the Mauritius Convention, they are still, the recordings are available on the ICSID website. So the state and the investor decided to do it this way. And we have this example from this small part of the world. So it will be.
Well, it's, yeah, can I just say
Yeah.
that, like, even without the applicable rules chosen by the foreign investor to bring the claim under the treaty, or the treaty itself providing for transparency, if the disputing parties say, well, let's agree on more transparency, it's sort of a win-win solution. Like, the arbitrators love to have more transparency, right? Because it's like free marketing, free advertising, right? If someone's really keen to see how they perform as an arbitrator by tuning into a live stream of their hearing, they're happy, the lawyers are happy, everyone suffers, or most people suffer from overconfidence bias, so they think they're better than they really are. So even if the proceeding is a disaster, it's like, in retrospect, most people, it's sort of too late. Most people have sort of, it's like the idea of making it transparent. And yeah, the reality is that some host states in particular, when push comes to shove, don't like actually the idea of having what's complained about aired in a very public way, either or indeed for their domestic constituents who otherwise like transparency, or even for the international audience. It might be embarrassing diplomatically.
Absolutely. So this brings us to another nuance in this discussion. Speaking of the different approaches from different countries, and plus the different attitudes of legal practitioners engaged in ISDS, would you say that there is a cultural influence in these decisions and the attitude towards transparency, or is it something that's has the universal tension just built into it?
So I think the traditional sort of major legal cultural difference we think of, even international law, say between common law and civil law, I don't think that really makes any difference, even if that's in any way perhaps over stylized. Many countries now sort of some sort of hybrid, but I think there is a bit of a difference perhaps in some countries and more in the socialist law tradition. So that's also reflected even in their skepticism towards the ICSID convention regime. So in Asia, for example, Vietnam, Laos, Myanmar, and so on have never even ratified the ICSID convention. Also, China is interesting because it compared to some of the other states that have signed treaties with ASEAN, the Southeast Asian nations, that had less transparency and so on. So I think that aspect, that socialist law culture, if you like, or tradition, might make a difference. Another aspect is whether the host state is a less a sort of emerging economy. So, for example, Indian treaties have not been noticeable until recently, in the new model BIT for having a lot of transparency. And then beyond that, beyond sort of a socialist law tradition country or a more developing economy, a third aspect could be sort of general culture, because we know from surveys and just anecdotal evidence that one of the more highly valued advantages of international arbitration over litigation in the East and Asia, for example, is in particular is compared to the West is confidentiality. Like, confidentiality in commercial arbitration is already quite a powerful incentive to use arbitration, and a valued feature according to the surveys and other evidence. But it's particularly so in the East. So maybe those countries like Vietnam and so on are going to be more cautious about transparency and investor-state disputes for that wider reason. But we need to be careful about not like overgeneralizing about general culture like that. It could be very linked to just, it could be specific to more commercial disputes, this preference or relative preference. It could even depend on which country you're talking about. Like obviously Japan, which I'm most familiar with, is different, say, from Korea, where I've also already lived and so on, and let alone China or Vietnam and Thailand, which I've also engaged with. So we have to be a bit careful there when we talk about general cultural differences, not stereotype or make too many overgeneralizations.
And Jen, I think also the reason why it's challenging to have the rules at the universal international level that will apply everywhere, because that entails a certain degree of generalization, which will either be rejected by the countries who do not see themselves within this framework, or it will be applied but lead to dysfunctional solutions. And this is why, on the one hand, seeking harmonization has its benefit, but on the other, having the global community falling under a certain set of rules will always be a challenge. But we are not seeking to find the global solution at this point. This analysis was still very valuable and provided many nuances. We will take the few more minutes that we have within this webinar today just to try to address what could be the next reasonable steps towards more transparency in ISDS, or in particular, maybe to narrow it down a little more. What would you say that will be the most attainable way to enhance it at this point? Would it be through more publication of awards, through the hearings, third-party participation? What do you think is the most attainable at this point?
Yeah, I think we need to look at it, in quite a granular way. So ideally, like each state, when they're negotiating these treaties, should try to work out why and how it's going to commit to transparency versus confidentiality. And as I tried to indicate, that might depend a lot on the nature of its economy, its background legal system, and so on. And that's sort of what we see now with this, like Australia's recent treaties with different countries build in transparency obligations that vary, and that's presumably because the counterparty wanted somewhat different outcomes, or there was some sort of give and take, some sort of concession on other aspects of the treaty negotiation. If you can't agree first on that in the treaty itself, then even after the investor has chosen some rules provided in that treaty, that maybe are older sets of rules, then that don't provide so much transparency, there could be scope nonetheless for disputing parties to agree on more transparency. And as I said, often it's like the foreign investor is quite happy with us. Or if it gets to arbitrator's discretion, we should be aware that, in exercising discretion, that shouldn't be a consideration, but maybe the arbitrator is quite happy to have a bit of transparency because it helps publicize themselves as arbitrators. And they think, of course, that they're going to write a fantastic award. So, so if you're one or other disputing parties and you're asking the arbitrator to use its discretion to publicize some aspect of the arbitration, you should keep that in mind and maybe push a bit harder to get your transparency. But lastly, when you get to like weighing the arguments and deciding whether, if it's not set out in the treaty or the rules, whether you should add more transparency, I think it's useful that council and the tribunal decide, are aware of the fact that it's a double-edged sword, as I've said, and there are competing interests which vary depending on what stage of the arbitration we're talking about. Also, obviously, once the award is out, making that public, for example, or is less invasive by definition to the arbitration procedure. So it shouldn't be such a concern compared to making public aspects of the dispute during the proceedings, like even to allow amicus curiae interventions, because that could significantly disrupt the efficient resolution of the dispute. So, I think, the transparency needs to be sort of weighed pretty carefully in terms of what aspects are being asked for transparency and what stage of the dispute resolution process, and the respective disputing parties, as well as the interests of the wider public.
Yes, I mean, just with this conclusion, we might delve into a whole other discussion about due process on the one hand and transparency in another, but we won't. We will keep it here in terms of the discussion about all these various aspects of transparency, which might seem simplistic in the beginning, but as you could all hear, with this short period of time that we have been discussing it, there is much to unpack in different perspectives on transparency. Dr. Nottage, if you don't mind, we do have a few more minutes, and we do have a couple of questions in the chat from Isla. So one of the questions, the first one is, what about parties specifically choosing arbitration because of confidentiality? Wouldn't transparency then deter parties from choosing arbitration?
Yeah, so that's very true for commercial dispute resolution. So for many years, I've served on the rules drafting committee for the Australian Centre for International Commercial Arbitration. And we've had quite a lot of discussions over the years about confidentiality. We introduced in our first set of institutional rules in 2005 quite a strict confidentiality obligation on the parties, and even requiring them, for example, if they produce witnesses, to make sure those witnesses are also bound by similar confidentiality and so on. Because overwhelmingly, completely, the centre is dealing with commercial disputes, not investor-state arbitrations. And we've considered over the years, and in even some webinars and so on, public discussions, whether we should relax some of that transparency in different ways, like procedural challenges to arbitrators. Should we, at least in an anonymized form, disclose the reasoning used by the tribunals, or KICA dealing with those, KICA dealing with those decisions. But in the end, the rules weren't changed. We've still got strict confidentiality obligations in our 2021 rules, because sort of the view in consultations and discussions is that most commercial parties really want that confidentiality, and even anonymized decisions, say on challenges, let alone awards and so on, like the ICC sometimes puts out, is likely to disclose actually who the parties were or whatever in the dispute. So, but for investor-state arbitration, really, it's the only game in town. Like, there's no, you haven't got many other good options in terms of a dispute resolution process to resolve your dispute with a sovereign host state, right? Other than, we're no longer in an era where you can get your home state to send their gunboats out to sort of blockade the ports of the host state and say, stop messing with our investors, or their investments they made in your country. We don't want to go back to those days, actually. So, and interestingly, I noticed there's recently a case, a BIT claim being brought against Ukraine, right, by China, but that's fine. This is like through an international law process with independent expert arbitrators who resolve this in a legal through a legal framework. And there's, typically there's the protections provided in domestic law and domestic courts in countries, even in developed countries, are not up to an international law standard. And of course, they're in the local language and the arcane procedures of that host state from the perspective of a foreign investor. And so there's no really other option. So So in answer to this question, no, foreign investors will still seek to get their home states to conclude treaties that provide for direct arbitration of host state substantive commitments, even if it involves more transparency, because there's no other good option. There's no, at the moment, unless we set up some sort of world investment court or even a bilateral investment court like the EU is now favouring with its treaty partners and so on. But until that day, there's no other good real option.
Mm-hmm. Yes, and just shortly, another question. You have addressed this on a couple of points throughout the session, but Isla is also making the point about, I think this refers to the deliberation process. Do you think that more transparency into the proceedings would then lead to a quicker deliberation process and reasoning of the tribunal?
Yes, I think that's what I started with. There's a lot of complaint in the international arbitration community, particularly amongst users, not so much about from the council, but the council lawyers in the arbitrations, because they're mostly on time charge, but about due process paranoia, where arbitrators are like becoming very cautious, perhaps overly cautious about allowing procedural objections and changes and so on to make sure that their awards don't get challenged. And then when they write awards, sort of writing out longer awards anyway, so that the parties and their lawyers can go back and say, well, we lost the arbitration, but this is the extensive reasoning behind the result and so on. And the concern is, well, this is all getting too much and going beyond one of the advantages of arbitration, which is a more streamlined procedure compared to litigation, where you have to have, of course, more elaborate decisions by the adjudicators, because there's also multiple layers of appeals typically, at least for errors of law. So you need to be much more clearer about your legal reasoning. But if it's the arbitrators deciding a commercial dispute between these parties that doesn't have a wider ramification, then why shouldn't you just be able to write a short, a succinct award? And so remains a good argument for more confidentiality. I see Denny's put up his hand. Do you want to have the last question, Denny?
Thanks. Actually, it's related to what you were just saying, because I was thinking about another interest of yours, which is mediation. Now there is a great push for mediation. And how does greater transparency relates to mediation? If we are seeking greater transparency and we know everything about the claim, like everything about the claim has become public, how can the parties involved then mediate?
Yeah, it's a good question. My PhD student, Anna Ubalava from Georgia, not in the US originally, she's finished her PhD on this and actually done an econometric study of the cases that settle in investment arbitration. And she makes the point that it's true that with settlements, there is less transparency in relation to the outcomes and so on, compared to the transparency nowadays, especially of awards decided by arbitrators. But actually, there's still quite a bit of transparency, at least around the outcome of the arbitration of the mediated settlement, and that usually means that there's a fair amount of information about the dispute itself. So if it started out as an exit arbitration, the parties, the lawyers, the nature of the dispute, generally the underlying instrument and so on, it will be on the exit website. Usually that then attracts various discussions publicly. If it's, for example, a listed company, they usually have obligations to disclose progress of the case and to their local stock exchange publicly and so on, because it could affect their share price. And then if you get a mediated settlement and you see the outcome, generally how much was claimed by the investor thanks to those other sources and so on. And yes, it's true, you don't know typically then why exactly the amount was reached or whatever, but there is some transparency, and it has the advantage also by having some confidentiality remaining there of getting to that outcome, right, and avoiding all the costs, paying the lawyers in particular and the arbitrators, the expert witnesses, to get to the award, even though then it's public and then you can see in often exhaustive detail in the award all the procedural steps and what happened in the arbitration. At the end of the day, like, most people don't really care, most taxpayers, even citizens, don't want that much detail. They want to know basically what the case was about, how much was claimed, how much was paid out in the end, and so I think they'll get that with settlements as well as awards these days, to a significant degree. Yeah.
Thank you very
Thanks
much.
for the questions.
Excellent questions, and obviously you have sparked the imagination and interest of our participants. I think Ms. Ubilava might get an invitation from us, because dispute prevention and amicable settlement will be crucial in, first of all, reducing the number of these lengthy and expensive arbitrations in ISDS, but also helping developing countries such as ours, such as Bosnia and Herzegovina and the Western Balkans, to balance the risk of these proceedings and try to maintain some control in the investment protection policies. So it's an absolutely important topic to cover on another day, and we will be happy to host Ms. Ubilava in the weeks to come. But with that, in respect of everybody's time, and also as we're knocking on the door of the weekend, I would like to thank, first of all, Dr. Nottage for a wonderful presentation and very engaging points that you have made, which we will be happy to explore further. Thank you to our participants. The recording will be available on YouTube and on the Association ARBITRI website. We will be happy to receive any comments or questions from you following this session, and we will continue our webinar series in the Fridays to come. So stay tuned, follow us on LinkedIn to see the next announcement, and we wish you all a safe and happy weekend.
Thank you.
Thank you. Bye.